All right, guys, welcome to the third part of Unit 6, Chapter 15, Expert Testimony in Digital Investigations. This is about 45 slides. Shouldn't take too long to get through. It should be one video lecture, hopefully. So, the objectives for this chapter are explain guidelines for giving testimony as a fact, witness, or an expert witness, describe guidelines for testifying in court, explain guidelines for testifying in the depositions, and hearings. Describe procedures for preparing forensic evidence for testimony. So, preparing for testimony. Fact witness provides facts found in an investigation, explains what evidence is and how it was obtained, does not offer conclusions, only facts. Expert witness has opinion based on observations. Opinions are formed from experience and deductive reasoning. Opinions make the witness an expert. For either type of testimony, establish communication early with an attorney. Learn about the victim, the complainant, opposing experts or fact witnesses, and the opposing attorney. Learn the basic points of dispute. Keep notes in rough draft form and record only facts. Keep opinions to a minimum. Confirm your findings with documentation. Corroborate them with other peers. It means compare your notes with other people that work in the same field as you. Digital forensics is only now developing a peer review process. Check out opposing experts to find strengths and weaknesses. Internet, curriculum vitae, deposition banks. So, when preparing your testimony, consider the following questions. What is the client's overall theory of the case? What is the story of the case? What can I say with confidence? How does my opinion fit into the theory of the case? What is the scope of the case? Have I gone too far? You can get out of scope really easily. Are my glasses on my head? Yep. Sorry. You can get out of scope really easily, and that can cause you to throw what you're writing out the window, because if your scope gets too big, let's say you're only supposed to focus on something the size of a paragraph, but you write out 3 pages, you're really off topic. You got to learn to narrow it down. That's what they're referring to. Have I identified the client's need for how my testimony fits into the overall theory of the case? Let's talk about documenting and preparing evidence. Document your steps to prove them reputable. Validate your tools and verify evidence with hashing algorithms to ensure integrity. Do not use a formal checklist. Do not include checklists to file a report. Opposing attorney can challenge them. Collect evidence and document employed tools. Maintain chain of custody. Collect the right amount of information. Collect only what was asked for, so don't overdo it. Note the date and time of your forensic work when starting your analysis. Keep only successful output. Do not keep previous runs. So if you have to run something 10 times and on, like, let's say the 10th time it came up exactly the way it needed to come out to match up with what they're trying to say, and that's exactly how it happened, just use that one. Don't use the other previous 9. Search for keywords using well-defined parameters. Keep your notes simple. List only relevant evidence on your report. To find any procedures you use to conduct your analysis is scientific and conforming to your profession's standard. List any textbook, technical book, articles by recognized experts, and procedures from authoritative organizations that you relied on or referenced during examination. So you're just going to make an appendix technically of what you've done, what book you read that showed you how to use this technique that applies to this, and yada yada yada, or website or whomever journal. Reviewing your role as a counseling expert or expert witness. Do not record conversations or telephone calls. Federal information requirements. Other cases in which you have testified as an expert witness in the last 4 years. 10 years of any published writings. Previous compensations for testifying. You gotta get paid for your time. That's essentially it. Evaluate the court's expert. Brief your attorney on your findings and opinion of the court's expert. Curriculum vitae. It's a French word. List your education, training, and professional experience used to qualify your testimony. Sort continuously enhance your skills. List any training, teaching, and experience. Detail specific accomplishments. List basic and advanced skills. Include a testimony log. Do not record conversations or telephone calls. Federal information requirements. Other cases. Yeah, why did I go backwards? I'm sorry, guys. Oh, weird. Anyways, ignore that. Sorry, this is gonna be a little weird in the video. I do apologize. Prepare definitions of technical concepts. Use your own words and language. So break it down so people understand. Examples of definitions to prepare ahead of time: digital forensics or computer forensics, hashing algorithms, image files and bitstream copies, file slack and unallocated space, file timestamps, computer logs. So these are all things normal people wouldn't know, so you can define what they are. So if they read them, they can look and see what yours says in your glossary of terms and definitions, and they're like, oh, that's what that means. Oh, okay. So they can kind of make sense of what you're saying. Examples of definitions prepared ahead of time continued. Folder or directory, hardware, software, operating system. Some legal actions generate interest from the news media. Reasons to avoid contact with news media. Your comments could harm the case and create a record that can be used against you. Hearsay, remember? You have no control over the context of the information a journalist publishes. You can't rely on the journalist's promises of confidentiality. Remember, they're after a big scoop for their career. They're not here to help you, they're here to help themselves. Procedures during a trial. Your attorney presents you as a competent expert. Opposing attorney might attempt to discredit you. Your attorney guides you through your testimony. Opposing attorney cross-examines you. Your attorney might have an opportunity for redirect examination of material addressed in cross-examination. That is a mouthful. You can be called later as a rebuttal witness. Typical order of trial: monotone and limelight. Limelight. Okay, that's weird. Impaneling the jury. Opening statements, plaintiff, defense, rebuttal, closing arguments, jury instructions. Demonstrate you are a witness expert. This qualification is called voir dire. Attorneys ask the court to accept you as an expert on digital forensics. Opposing attorney might try to disqualify you because of your CV and experience. Let's skip one again. Sorry. Oh, we're good. Sorry. The trial was typical. I did this already. Why is it going back? Sorry, guys. It's jumping all over the place today. Okay. So be professional, be polite, be courteous of the judge, jury, judge, and attorneys. If asked something you cannot answer, say, this is beyond the scope of my expertise. I was not asked to investigate that. Avoid overstating opinions. Guidelines on delivery and presentation. Always acknowledge the jury and direct your testimony to them. You're trying to, it's a court of your peers. You're trying to influence them, not the opposing attorney. Guidelines on delivering procedures continued. Movement. Turn towards the questioner when asked. Turn back to the jury when answering. Place microphones 6 to 8 inches from you. Use simple, direct language to help the jury understand you. Avoid humor. Yeah, it's an email. Not important. Build a repetition into your explanations. Use chronological order to describe events. If you're using technical terms, identify define terms for the jury. Remember, the jury's going to be just a group of 12 random people. They're not going to know all the technical stuff. So you got to break it down. Cite the source of the evidence the opinion is based on. Make sure the chair's height is comfortable and turn the chair so that it faces the jury. Guidelines of delivery and presentation continue. Dress in a manner that conforms to the community's dress code. Don't memorize your testimony. For direct examination, state your opinions. Identify evidence to support your opinion. Explain the method used to arrive to that opinion. Restate your opinion. Prepare your testimony with the attorney who hired you. How is data or evidence stored on the hard drive? What is an image or a bitstream copy of a drive? How is deleted data recovered from a drive? What are Windows temporary files? And how do they relate to data or evidence? What are system or network log files? Using graphics during testimony. Graphical exhibits illustrate and clarify your findings. Your exhibits must be clear and easy to understand. Graphics should be big, bold, and simple. The goal of using graphics is to provide information the jury needs to know. Exhibit A, Exhibit B, Exhibit C, etc., etc., etc. Review all graphics with your attorney before trial. I mean, you can't just take them out without showing them to your attorney because they're not going to know what they're trying to do. You got to explain what you're trying to do. Sorry if the sunlight's making me seem like a shadow today. Make sure the jury can see your graphics and face the jury during your presentation. Because remember, you're trying to convince the jury of whatever they're asking you to explain. Now it doesn't go next, of course not. Avoid testimony problems. Recognize when conflict of interest issues apply to your case. So that means investigating something, but you worked for them in the past, or you're a friend of yours, that could be a conflict of interest. So you wouldn't take that kind of case on. Conflicting out. An attempt by opposing attorneys to prevent you from serving on an important case. Avoid agreeing to review a case unless you're under contract with that person. Avoid conversations with opposing attorney. You to receive payment before testifying. Don't talk to anyone during court recess. If a juror approaches you, decline to talk with him or her and promptly report the contact to the attorney who retained you. Make sure you conduct any conferences with your attorney in private settings. Understanding procedural misconduct. If you have found exculpatory evidence, you have an obligation to ensure that the evidence isn't concealed. Initially, you should report the evidence to the prosecutor handling the case. Be sure you document the communication. If this information isn't disclosed to the defense attorney in a reasonable time, you can report it to the prosecutor, supervisor, or judge. Techniques during direct examination. Techniques. Working with your attorney to get the right language. Be wary of your inclination to be helpful. Review the examination plan your attorney has prepared. Provide a clear overview of your findings. Use a systematic, easy-to-follow plan for describing your methods. Break it down A, B, C, D, and E, A, 1, 2, 3, 4, 5, etc. Practice testifying. Use your own words when answering questions. Techniques continued. Make sure you know the following terms before giving testimony. Independent recollection, customary practice, documentation of the case. Present your background and qualifications. Avoid vagueness. When you use graphics in presentation, make sure the jury understands your explanations. Recommendations and practices. Use your own words. Keep in mind that certain words have additional meanings. Be aware of leading questions. Never guess what you do not have an answer. When you do not have an answer. Be prepared for challenging, pre-constructed questions. Did you use more than one tool? Rapid fire questions. Sometimes opposing attorneys declare that you aren't answering the questions. Keep eye contact with the jury. Sometimes opposing attorneys ask several questions inside one question. It's like a multi-faced question, essentially. They'll slam me with. We're almost done, guys. 15 more slides. So this lecture is going to be pretty short. This final should be pretty interesting when I have to cover all these chapters. One thing I should mention, I noticed I said some cover units 6 and 5, but the last part, unit 4 to the cloud part, that'll be in there. So there'll be some questions on not too much. Probably less on this stuff, to be honest with you guys, because this kind of doesn't really have a lot to do with it, how to do something in digital forensics. Is more of a law part, so we still got to know it regardless, but I'm not too deep on this end, you know what I mean. Attorneys make speeches and phrase them as a question. Attorneys might put words in your mouth. Be patient. Most jurisdictions now allow the judge and jurors to ask questions. Yeah, it's actually true now. Avoid feeling stressed and losing control. Never have unrealistically high self-expectations when testifying. Everyone makes mistakes, and we're all human, guys. Avoid the following: being argumentative when being badgered by the opposing attorney. That can make you look like you're lying, or what's what I'm looking for? Unprofessional, and this way they won't believe you. Having poor listening skills or using defensive body language. Being too talkative or talking too fast. Being too technical for the jury to understand. Acting surprised and unprepared to respond when presented with unknown or new information. Deposition. Differs from trial testimony. There is no jury or judge. Opposing attorney pews your testimony in trial. Discovery deposition. Part of the discovery process for a trial where they just request information. Testimony preservation deposition. Requested by your client. Preserve your testimony in a case of scheduled conflicts or health problems. Some recommendations. Stay calm, relaxed, and confident. Maintain a professional demeanor. Use name of attorneys when answering. Keep eye contact with attorneys. Be assertive in your responses. Be professional and polite. Use facts when describing your opinion. Being deposed in a discovery deposition is an unnatural process. If you prepared a written report, the opposing attorney might attempt to use it against you. They'll poke holes in your theory, If your attorney objects to a question from the opposing attorney, pause and think of what direction your attorney might want you to go. In your answer. Be prepared at the end of the deposition to spell any specialized technical words you used. Recognizing deposition problems. Discuss any problem before the deposition. Identify any negative aspect. Be prepared to defend yourself. Avoid omitting information. That's withholding information. That's technically illegal. Having the attorney boxed into a corner. Contradictions. Be professional and polite when giving opinions about opposite experts. To respond to difficult questions that could jeopardize your client's case, pause before answering. You gotta take a breath and think about it sometimes. Keep in mind that you can correct any minor errors you make during your examination. Discovery deposition testimony often doesn't make it to the jury. It might be presented to the jury, usually as part of an attempt to discredit the witness. Boy, guidelines for testifying at hearings. Almost there, guys. About 7 more slides. Excuse me while I yawn real quick. Testifying at a hearing is generally comparable to testifying at trial. A hearing can be before an administrative agency or legislative body in a court. Like imagine testifying to Congress or something. Often administrative or legislative hearings are related to events that result in litigation. A judicial hearing is held in court to determine the admissibility of certain evidence before trial. So they kind of got to review what you guys are trying to submit. No jury is present, so yeah, it's just you guys. And we might do this as a lab and write down the slide. Even though we technically already did something, this might have some more juicy information in it. So, slide is this 39. Excuse me. Yeah, I think I may have given you guys this already. I'll check. If I did, don't worry about it. So, preparing a defense of your evidence collections methods. To prepare for testimony, you should prepare answers for questions on what steps you took to extract email metadata and messages. You might also be asked to explain specific features of the computer operating system and applications such as Outlook, for example, and explain how these applications participate and digital forensic tools work. So you imagine the Outlook is a email system that does this, this, and this, yada, yada, yada. On to the summary, guys. We're done in less than 20 minutes, I think. Cool. When cases go to trial, you as the forensic expert play one of two roles, a fact witness or expert witness. If you're called as a fact or expert witness in a digital forensic case, you need to prepare for your testimony thoroughly. When you're called to testify in court, your attorney examines you on your qualifications to establish your competency as an expert or a fact witness. Make sure you're prepared for questions opposing counsel might use to discredit you, confuse you, or throw you off track. Know whether you're being called as a fact witness or expert witness or both, and whether you're being retained as counsel expert or expert witness. Depositions differ from trial because there is no judge or jury. Depositions usually fall into two categories: discovery deposition and testimony preservation deposition. God damn, it's a mouthful. Guidelines for testifying at depositions and hearings are much the same as guidelines for courtroom testimony. Make sure you prepare answers for questions on what steps you took to collect and analyze evidence and questions on what tools you used and how they work. All right, guys, that's all I have for this part of Unit 6, which is Part 3. I will see you in Part 4. Take it easy.